Okay, so welcome everyone to our Global Training and Professional Development's Lunch and Learn session today. So today we're very honoured to have Dr. Laurence Boulle, AM, with us. So I first met Laurence back in the early 1990s when he was the co-director of the Dispute Resolution Centre at Bond University. So Laurence has over 30 plus years of teaching and training in dispute resolution and is highly experienced in having to manage the haggle in many of the disputes that he negotiates and oversees in those mediations. So what I'd like to do is to just tell you a little bit about Laurence. Firstly, I know that Laurence is humble and doesn't like me to say too much, but I think that we need to know that Laurence has written and co-authored many well-known and well-used texts around international negotiation, mediation and conciliation, and around process and skills for mediators and conciliators and for negotiators. So his most recent book was published in 2023, and that's titled Mediation and Conciliation in Australia. He also has done a text for the US, which is more in line with their legal system and their protocols and policies in the US. So that mediator skills and techniques also came out last year in 2023. So Laurence tends to do a lot of mediations in the commercial area, in community, family, workplace, personal injury, native title, so a whole range, diverse range of disputes. And I know that today he'll be able to share some of those experiences that he's had in managing the haggle in those mediations and negotiations that he has conducted in those areas over the years. So welcome, Laurence. Thank you for joining Global Training and Professional Development today. So, Laurence, what I'd like to do to start is I think we should define what is the haggle. So, what exactly is the haggle in negotiation and mediation?
Well, welcome to all those online. And Robyn, the haggle is what we do every weekend. When we get online and we're looking for that bar fridge, which we want to put in the corner, and the vendor wants $120 for it, we say, you must be dreaming, and we offer them 60. They come down to 100, we go up to 70, and so it goes on. So in fact, it's a nice, I think, little kind of slightly irreverent view for a certain style of negotiation practice. And if anyone is over the age of 50, they'll know it from Monty Python, the famous haggle scene in Monty Python.
I recall that haggle scene in Monty Python, Laurence. But isn't dispute resolution about interest-based bargaining and mutual gains? Is it really about overseeing the haggle?
Well, this is a kind of a key point of discussion these days. And of course, everything we acknowledge now is culture dependent. And I don't only mean that in kind of ethnic and religious such cultures, but, you know, I'm coming to you from the Cumbermary Nation, and there would be different assumptions about negotiation, dispute resolution. But in certain commercial and business and other cultures, the haggle would be just part of the way business is done and disputes are resolved. Even though you and I, Robyn, for years have taught interest-based and mutual gains and problem-solving dispute resolution, the reality of life is it's very mixed out there. So I think what we've taught is highly appropriate in some contexts. And I think towards the end, we may be able to draw out some of the interests underlying the crude haggle and see how we can, in a sense, get back to those basics. But I guess this is where theory meets practice, and we have to acknowledge that a great deal of dispute resolution practice is about haggling, often over money, not always.
And I think you're right, Laurence, that we need to know how to do both and what's the intersection of both of those. And when is one style more appropriate than the other, and how do we shift from one style into the other style, depending on what's actually happening in that negotiation. And, you know, as we've always said with skills, there needs to be a purpose behind everything that we do. So I guess this webinar is about just understanding the purpose of the haggle in negotiations and mediations, and, you know, when is it culturally appropriate to do it on all different definitions of culture. So how does the haggle look in the big picture?
I mean, a bit of it depends, Robyn, on the context in which we're operating. So, for example, in a personal injuries matter, it's going to look a bit different from where family practitioners are negotiating over the exact time of the Wednesday contact. And that will look, again, a bit different from a commercial matter where the haggle is over the make good obligation for tenants after the lease has come to an end. So a few differences there, but in our context, yeah, to kind of simplify all of that complexity, which is sometimes useful, perhaps you could just show a short slide on what the haggle might look like, and some of you will identify and recognize that immediately. So if we could have that slide, please, Robyn.
Okay, so Laurence, just tell me which slide. Is this the slide we're looking at?
No, the next one, Robyn, if we could. The next
one? Okay, let me just take us to the next one.
So that's a great way of, in a sense, portraying the haggle, because it takes time. So let's give some context to this. I'm not sure of the backgrounds of all participants, but many of you would recognize a kind of one-dimensional negotiation, dispute resolution, mediation, conciliation over dollars. It could be over time. It could be over the percentage of net of the net asset pool and so on. But it will begin, and we'll go into a bit more detail about how one may begin and run this, but normally with a high number. Yeah, it's a 1,020,000. As opposed to a low number on the other side. So let's contextualize this as an injured worker bringing a workplace injury claim and the insurer on the other side. And what the haggle essentially involves, and this can be done either face-to-face, but more normally in a shuttle context, is really, at its crudest level, an exchange of numbers. Now, there's more to it than that, and there's a lot of signaling, and there's a lot of noise around it, or there can be. But what we can see there is a slow set of incremental concessions being made on each side. And I think if you do one more click, Robyn, we'll see that this one succeeded beyond all expectations. So over the course of about 3 hours, this haggle, which amounted essentially to the swapping of numbers, to put it crudely, resulted in an outcome. So that would be a picture which could be replicated, say, in the unfair dismissal context, where somebody is seeking, say, 36 weeks, the maximum that can be attained, and the employer is offering 4 weeks, and it may be much quicker and shorter than this, but the essential elements of it would be similar in those many different contexts. So that's a starting point of how the haggle might look, Robyn. Okay, and do you want to talk a little bit about some of the tactics that hagglers use when they're doing this? You mentioned, Laurence, that it essentially is an exchange, in the crudest form, an exchange of figures. Yeah. In monetary terms, but there are other tactics that characteristic of hagglers in negotiations and mediations. So do you want to describe some that you've seen in your sessions? Yeah, and initially, Robyn, we kind of looking at it without the intervention of a dispute resolution practitioner, such as a conciliator or an FDRP, but just to see, how this might look. So I think as that slide suggested, there can often be extreme openings with a haggle, or what are sometimes called ambit claims, certainly in the industrial relations context. But in simpler kind of language, each side starts either high or starts low. And that is, of course, a culturally determined factor, because if the commencement, and I've seen this in practice, if it is too high, the other side will either say, look, not prepared to negotiate today, or will come back with an absurdly low number on the other end. And that has, in a sense, muddied the waters already, because we're not operating within these kind of cultural expectations. A lot of this is about expectation.
Yeah.
So in terms of your question about the tactics, I guess the first one is how to commence it. And of course, in many legal contexts, the pleadings or other documents will have, in a sense, set the parameters. However, I've seen sometimes in practice where a schedule of damages is claiming, say, $1 million. I've seen people start at 1.2 million, and that has also slightly contaminated the climate of the negotiations. So that would be the kind of initial thing. How should one begin these? And if you're a dispute resolution practitioner, how might you educate and normalize the behavior? But we'll come to that in a moment. So I'd say that's the first kind of starting point.
Right. So it's kind of like trying to move people out of those insult zones in that negotiation. Because as we've seen many times, that if people do come in and they make an insulting offer, as you've said, the other side will either walk out or they'll make an equally insulting offer. And then, your job as the mediator, the dispute resolver, is going to be even harder, because you've got to then move people out of those insult zones into, a more reasonable target kind of zone for that negotiation. And I guess that's what we saw in that chart that you just showed, was that they did start kind of in those outer zones, very high, very low. And then over time, it moved into a more reasonable target kind of zone where they may be able to negotiate and settle.
Yeah, no, I like that descriptor of the insult zone, and experienced people in this area will kind of know where that is. Unfortunately, the studies suggest that if the haggle is the game in town, it is better to start as high or as low as you can, as long as you're not in that insult zone. That gives you something to play with. It also, and this is something which kind of comes up at the end if we get there, Robyn, but one of the big concerns with the haggle is each person thinks they've conceded too much.
Yes.
This is a normal humanistic aspect of it. So what is too much will be partly a function of where they started off.
Okay, so do you think there are any other sort of descriptions of how it proceeds during the haggle that might enlighten some of our viewers today to be aware of? So we've talked about the start. Where does it go to from there? And then how does it end?
Yeah. In the shuttle context, Robyn, it tends to be quite sanitized in a way, with not a great deal of noise around it. So it is, as we discussed earlier, a bit of an exchange of numbers. And those will be done on an incremental basis and will be done normally in quite a conservative fashion from both sides. Because the numbers are also signaling in some or other way the intention. So, for example, if somebody repeats a number twice, say the insurer says 250, and the next round says 250, that's a suggestion that perhaps the brakes are being put on, and that may induce a bigger concession from the other side.
Yeah,
I think the short response is that most experienced representatives will play the so-called incremental game fairly cautiously. That was a particularly long session that took, I think, about 3.5 hours. But sometimes it's played out in a much kind of shorter time span. And so, making conservative, cautious incremental counter proposals as we progress. I'll just touch on that other point, Robyn. Is it okay, or does it occur that people will stick on their previous number? And the short answer is of course that does happen It can be dangerous. It can, on one hand, create doubt and help the other person to move a bit, to shift their stance, or it can muddy the waters and cause some anxiety and even a deadlock.
Yeah. So, Laurence, I guess, we've got some FDRPs in the room, I'm sure. And I know from some of the family mediations that I do, when we get to this haggle kind of stage, and particularly in property disputes, division of the matrimonial assets, that, I often see this is where parties will use particular tactics like their, tantrums, threats, lies and bluffs. I mean, I see people throw tantrums and, do the whole throw their hands in the air. How can I possibly cope, without 5 properties under my belt at the end of the day? Do you want to talk a little bit about those tactics and how they relate to some of these?
Yeah, and again, this is not an academic point, but there's an interesting article on good practices, tactics, and tricks, and all of the experienced people in the session will have experienced a combination of those at different times.
Yeah.
And I guess that, and I'll come to this later, but I guess the first thing for the practitioner, as opposed to the poor client who may be feeling completely exasperated and kind of have real ego depletion, where's this going? I'm not getting what I wanted. I guess the first thing is to put your own oxygen mask on first before helping others. So it's obviously a metaphor from the delayed flight you took last week. And in a sense, to understand how we react to the frustration of, for example, how slowly it goes. But I think also recognizing that within those patterns, there is a kind of a logic. So a claimant, and this could operate in the family property area, Robyn, a claimant actually wants a large number of concessions from the other side, because there's a kick of dopamine each time they win another concession. Unfortunately, the respondent has the converse. They don't want to keep giving. So I think just these kind of awareness of kind of, if you like, the emotion or the psychology of this is an important awareness factor. But the example you gave is a really good one, because I would put that in the tactical trick category. And there is, apart from kind of clinical creating doubt to get more concessions than you give, which we could come to in a moment, which would be wholesome, quite legitimate. There can be overbearing threats and walkouts. I mean, we've all had a few walkouts over the years. And those can, in a sense, amount to unprofessional or even unethical negotiating behavior. And I think as practitioners, we have to be abreast of those.
Yes, I agree. Okay, so are there any kind of invisible factors that influence the haggle that perhaps, we're not aware of, that we should be aware of? And I heard you speak a little bit there, about some of the, I guess, neuroscience behind and the psychology behind the tactics that negotiators use and representatives often use in our mediations. So are there any kind of invisible type things we should look for or be more aware of?
Yeah, again, I mean, this is a massive field, and we're all trying to keep abreast of the without being neuroscienced out and wondering what we do with this. Yeah. But I mean, just some of the ones I've alluded to. First of all, that the so-called claimant will want a number of concessions, which is evidence of their persistence and their negotiation skills, and that's not matched on the other side. But kind of, I think some of the issues which are kind of a realization that this is not just a clinical exercise in number crunching. And if we want to get into, some of those hidden factors. Just to touch on one or two. First of all, we all know about the sympathetic nervous system, that in a high conflict where there is aggression and bluffs and tricks and so on, it induces a state of mind that's not conducive to negotiation or dealing with the haggle.
Yeah.
And that may require things like a timeout, or putting your own oxygen mask on first as the representative or as the dispute resolver, depending on your role there.
Yeah.
So that the parasympathetic nervous system can take over and restore us. And we no want, because what we don't want is defensiveness.
Yes.
And as soon as we feel threatened, then defensiveness comes in, and so the haggle kind of hits a serious bump in the road.
So
the other one.
Sorry, Laurence, go ahead.
Go ahead.
So I was going to say, from what you're saying, it's kind of getting the balance right between allowing the haggle to happen and monitoring it and facilitating it in a constructive manner, but being aware of the things that will derail it. And then having those additional skills to be able to calm, the limbic system, that, so people are not operating out of that fight, flight, freeze kind of mode, or getting stuck and anchored on a number or a percentage, and then not being able to do the haggle. So it is about as a mediator or a dispute resolver, getting that balance right, isn't it, in the room?
And Robyn, just on that point, a couple of weeks ago, I had, in this case, I was the intervener, so I was the dispute resolution practitioner, and it was going to be a haggle, yet another workplace injury, psychological injury. And it was so pleasing to see that even though this is how the exercise proceeded on those monetary lines, the exchange of numbers, both the representative of the injured worker, the claimant, and of the insurer were actually excellent in terms of what we might call the non-monetary factors. So acknowledgement, a real sense of dignity on all sides, and even from the insured, I shouldn't say even, but an insistence on coming back into joint session. It ended up successfully. Good. And acknowledging the stress that had been caused, and wishing the injured worker all of the best. So I think when we get stuck in the haggle, we can often think the only criteria of success is how much we get and whether there is or isn't a settlement. Whereas we all know there are these non-monetary factors, Robyn, that play such an important part.
Yeah, and often more important. We can often quantify some of those, and I'm sure you'll talk about some of that a little bit later when we talk about some of the skills we use and the interventions we use, Laurence. So maybe kind of now is a good point to start talking about some of the interventions, or is there anything else you'd like to mention before we move there?
Well, no, let's. I think it's a good time to move into that, Robyn. But we can always backtrack a little if necessary, because I think we're talking as a kind of a wide angle here for both representatives and dispute resolution practitioners, and of course there may be people from the business or management who are doing this themselves. So we really try to cover all of those eventualities in terms of, and there'll be a slightly different nuance for different participants.
So Laurence, before we go there, can I just ask, when you were talking, that example you gave before, which kind of showed the monetary and the non-monetary and how important both were to getting that resolved at the end of the day, can I ask what role you think intake sessions play in preparing parties and or representatives to be able to understand and know how to do this appropriately? So around coaching, maybe the representatives and the parties, do you do that with your mediations and your negotiations?
Yeah, certainly in
Very the
commercial
same?
contexts, Robyn, I do quite a
Yeah,
lot of that.
yeah,
That initial reality testing and also anticipation and I'm sure most, and we're really looking at a little more now from the dispute resolution practitioner, the conciliator or
yes,
mediator or
yes,
facilitator. In some contexts, the culture doesn't lend itself to that, and the way the matters are set up, there's very little of it. So
yes,
in the Fair Work Commission, very skilled conciliators do some of that in the opening session and some of that in separate sessions.
yeah,
But there's very limited scope for doing that beforehand, except actually under a new trial project that the Fair Work Commission is conducting. But I really like that focus on, if you like, the the settling the expectations.
yes,
So
managing
to go
those.
back to the injured worker, it's important, and they've heard it 3 times but may have missed it, that all the insurer is looking at is past and future economic loss.
Yeah,
So any other pain and suffering, et cetera, it just isn't part of the equation. So I think that would be a pretty good example of what you're talking about there, Rob. And I suspect in family property, which you know better than I, there would be many similar examples where expectations are
yeah,
out of bounds, and
yeah.
there needs to be that sort of management function.
Yeah, so really making sure that we manage those expectations up front,
Yeah,
and or during the mediation, and ensuring that parties have had some advice, some legal advice or some representative advice, some commercial advice before they come into these negotiations, so that they understand the range. So
yeah,
even that one that you showed us on the slide, that had a range in it.
yeah,
It might have
yeah,
been a bit kind
yeah,
of towards the outer ends of the range, but it was within a range that could then be settled later.
yeah.
Um, yeah,
No,
okay.
that's a good point, because that is an example of a very well-worn area of haggling, and therefore it has lots of precedents, lots of
Yeah,
cultural understanding about how it operates, so that the range then
yeah,
becomes much more specific, and it's where within the range there might be a settlement.
yes. Because too often we see people arrive, you know, at a dispute resolution process and they're really fixated and anchored on a figure or on a position or, on what they believe their legal advice has been,
Yeah.
around a specific number. And
Mm.
that then makes it very difficult to kind of shift people because of that anchoring and confirmation bias and just not
Yeah.
being willing to kind of do the haggle.
Mm.
So,
Yeah, exactly. Yeah. And so
yes,
they would come in and do what's called reasonable firm negotiation, which is to say, well, look, we've considered all options, we've taken advice, we've whatever, and this is our number, with the expectation that it will be accepted. But that might be culturally inappropriate. In some cultures, that
yes,
may be entirely appropriate. And
yeah,
again, I don't
yeah,
necessarily mean ethnic cultures, but
yeah,
it may be appropriate. And our old friend, Robyn John Wade, used to
yes,
say, give me a range on each side with a 20% difference in the
yes,
numbers, which is kind of
yeah,
voice of reality, saying don't
yeah.
come fixated on a single number.
No. And, sometimes we get it and sometimes we don't, Laurence. So, as dispute resolvers, we have to work with whatever we have on the day. But we do our best to try and manage a lot of that prior to starting. Okay, so you touched a little bit before on our responsibilities as dispute resolvers, as practitioners in the haggle, and that, ethically we need to make sure that we are managing behaviour that perhaps isn't appropriate in that style of negotiation they may be adopting, or one party may be adopting to try and intimidate or pressure or, coerce the other side. Um, can you give any examples of any other responsibilities that we have and should be aware of as practitioners?
Well, I think they're the sort of the generic, the overall responsibilities, and then there's some tricks. So perhaps if we start the overall responsibilities, I think, and this is kind of standard dispute resolution understanding, is to point out costs and risks. So this
Yes.
is the
Yes.
age, the agent of reality factor.
Yeah.
And there are different ways of doing this. So one of the ways that that I do it is, for example, bringing either into screen share, or if it's face to face, a copy of a judgment from a New South Wales Court of Appeal judge, in which he completely devastates the whole notion of going to court, points out all the shortcomings. So it's not me. This is a high status legal personality who's saying, don't go there, so to speak. Funny enough, I did a mediation a couple of months ago, face to face at a certain in the precincts of a certain casino. So we made lots of jokes about, well, if we don't settle now, it's litigating. Representatives don't like this, but we can do it, Robyn. Litigating is like going to the casino.
And sometimes humour is really important, Laurence, if it's done appropriately. In managing those mediations and negotiations, and managing the haggle with parties, that just to kind of break the ice a little bit. So talking about breaking the ice, we're going to move on and talk a little bit about specific interventions. Before we do that, though, I am aware that we have quite a few participants on. And I forgot to mention up front that if you have any questions or any comments that you'd like to make on this session with Laurence, please put it in chat. And I'm monitoring that chat. So I'm sorry I forgot to mention that up front, but we're only part way through, so you still have an opportunity to do that. Okay, so Laurence, what I'm going to do is to share your slides again, because I want to just kind of start looking at some of the specific interventions. And as we all know, even with the best kind of will in the world and having, knowledge and skills, sometimes as dispute resolvers, oh, sorry, where did that go? Let me just take us back. Sorry, I'll do that. Bear with me 1 minute. I'll go back to this one, and then I'll bring it up as a full screen. Okay, so sometimes we kind of feel like this, or the other negotiator may feel like this with the parties. So let's talk a little bit about, even with the best kind of knowledge and skills, not all haggles can be managed and resolved. What's your view on that?
Definitely. And I think sometimes we feel, as the professionals in the room, a bit overpowered by this. I suppose, and this would be a tactic stroke trick, and all of you would have encountered this in some or other form over the years. And I suppose that the first point is to try and diagnose it. So it's certainly a suggestion of a lot of not only aggression, but underlying aggression would be, dissatisfaction and anxiety and so on the other side. So I think we're always kind of making provisional diagnoses as to what is going on in the room, and that may be right, or that may be wrong. So many people would try and break this pattern by going into separate sessions. And others may be braver and try and deal with it when it occurs. And that, in dispute resolution, we think along a spectrum, not in binary terms. So it could be that people have been negotiating like this all their lives, and they know one another, and there's no harm done, so we let it go. And I've actually had a very dramatic example of that, where the representatives, we invited them to leave the room, which they agreed to, and these two just went for each other like this. And I intervened with a summary, and they said, please be quiet, this is going fine. And 10 minutes later, they shook hands and they had a deal. So that's from one extreme to an attempt to acknowledge. Acknowledgement is really important in human affairs. Something here is clearly upsetting and is leading to this kind of behavior. Shall we explore that for a minute? which would be kind of an intermediate one, through to, abandoning the whole process and reporting them for breach of ethics and so on. So I think we're always implicitly hypothesizing what's going on and making a call, and we may be right or we may be wrong. But increasingly, I don't know about you, Robyn, but I feel that I have an educative role in dispute resolution.
Yes,
and it just
definitely.
I'm normalizing, this is what happens, or gently advising, even though we're technically advisors. That would be part of your practice.
Yes, it is part of my practice. And, I think we do have quite an educative role as FDRPs, as well as in commercial disputes and, other types of general disputes that we do with parties. I think, people are notoriously not good at negotiating in their own best interest. And in FDR, in their children's best interest. So, sometimes they really do require some coaching and some education around, what are your goals? What are your risks? What are you trying to achieve here? And is that behavior going to achieve your goals or not? So often people lose sight of what they are when they get into that haggle and into that negotiation. But I want to just mention what you just said a few minutes ago, that because I do a lot of my mediations are international, and a lot of them come out of Hong Kong and with Chinese parties, there have been times where the parties are really getting into it, and I've actually kind of tried to stop them and calm it down and just check, are they okay with this, what is happening in the room? And I learned very quickly through a number of clients' parties who would say to me, it's okay, Robyn, we actually know what we're doing. We've done this before. We'll be back to you in a moment. And I check in with the other party. Are you okay with this as well? And they say yes. And, as you said, so long as they're okay with it and no one is being intimidated or coerced or threatened or, bullied into something, I'm okay to let them go. And then they ultimately do turn to me and go, okay, we've sorted that one out. This is how we're going to do it. Now we can move on.
That's the kind of performance
cultures I work in, that's totally acceptable.
So it's kind of a performance art on each side, and it has a function. And as you've rightly said, the judgment is made not in terms of our comfort or discomfort, but in terms of the client's needs.
And I had to learn that, because it was my discomfort that I was, and it was also because I had learned the Western model of, mediation and negotiation, and that, ethically we should be really protecting parties. And then I kind of went, you know what, this is empowering for them. They actually know how to do this. They've been doing it for years. Okay,
Robyn, sorry, you go ahead, because
so one of the things that I know that I've seen you do, Laurence, that I'd like you to talk about is I've seen you write the word gain up on the whiteboard when you have been, overseeing some of these mediations, negotiations, and when you've been doing trainings around this. And I think it's really important for people to kind of understand why you do that and what the psychology behind that is.
No, that's a great one, and thanks for bringing that up. So, and there's a lot written about this, and I think a lot of representatives and others are familiar, but it's worth emphasizing the importance of four-letter words in dispute resolution. And so the issue here is, if we go back to those numbers we had on the board, is that the claimant who started off asking for $1 million and is now down 3 hours later at 700,000, what is their dominant perception or belief going to be? It is, we have lost here. We have lost the 300,000 that we've conceded. And a similar perception or belief, and I think nowadays we talk a lot more in terms of beliefs on each side, which are cognitive things. They're not feelings. It's a cognitive belief. It's wrong because, as the insurer, we've conceded 250,000. And so at a certain point, I think one of our responsibilities is, as Robyn has implied, to reframe from loss to gain. And to point out, say to the claimant that when they came in, they were asking for they actually had zero. There was nothing on the table, and now they're up to 700,000. So to try and reframe from gain. The theory behind it is that when people perceive they're losing, they're more likely to take a risk. Okay, let's go to the tribunal. If people perceive there's a gain to be had, they're more likely to be conservative and be risk averse and to take what's on the table. And the counter applies to the other side. So I think the whole loss gain thing is so important, both in terms of how we speak and what we point out to each side, and also where visuals are available, whether on screen share or the whiteboard. It's in a way of emphasizing that. And does it always work? Well, not always. I had one party say, this is in an open session, I do a lot of work in open session, say to me, yep, I understand that, but they're gaining more than I'm gaining. So they still had that kind of loss perception.
Loss perception.
So we try these things, but I think that's one of the most important ones, to shift from loss to gain, because that may create greater acceptance for the deal on the table.
Good, thanks, Laurence. And I think the other thing that I found personally really helpful in my mediations that I've done is how you do the proliferation of the issues to try and get more on the table. So do you think now's a good time to maybe show that to our participants here today?
Robyn, this is a really good topic and so important for experienced dispute resolution practices, because we have to add value to what's going on, even if it is the haggle. I'll just give one anecdote, and then if you could pull up that slide, please.
Okay.
So we know that this is the kind of cultural context in which an exchange of figures is going on, and it may take half an hour. I think the record I had once, it was like 20 minutes and they settled, or it may be protracted and maybe adjourned and keep going. However, and this goes back to one of Robyn's earlier questions, what happens to interests here?
Yeah.
Well, the answer is we keep looking for them. So in a case involving compensation for relatives act case, a person had died, an electrician removing power lines which hadn't been connected, died instantly. And his in terms of the legislation, his bereaved wife was able to bring the case, was to bring the compensation claim. Now, this is actually a long story with a very rich kind of fabric to it. But to bring it to a head, what was the interest of this person? It was a very big claim that was being brought, and it was being stoutly resisted by the insurer on predictable grounds that there was contributory negligence. One of the underlying interests only came up after about 2.5 hours, and that is she wanted her late partner to be exonerated from blame for his own death, which of course wasn't the way it was being played out by the insurer, which was arguing the contributory negligence, and that was really offensive to her. And to her surprise, the other side agreed to that. And it was a real deal maker. So she could go home and say, it was tough. I got the money, not what I wanted. But you know what? He was exonerated from blame. They didn't insist on that point. So I think that was a classic case of us, Robyn, doing what we know best, and that is looking for interests.
Yeah, and some of those psychological interests are just as important as the substantive interests, the monetary interests, which is what that case has just kind of shown. Yeah. And again, we have an educative role there to, in separate sessions or in shuttle, to kind of help the sides understand that this is not just about money.
Yeah.
That at the end of the day, if they're going to get a deal today, if they're going to get this resolved, they actually need to acknowledge those interests and those feelings, and do something with it in that session so that that person can move on and then be able to resolve matters.
Yeah.
Yeah.
And it was a classic negotiation thing of something being valuable to receive, but
Yes.
cheap to give. I mean,
Yes.
it kind of satisfied that
Yes.
old thing
Yes.
we've talked about.
Yes.
So that's kind of outside the money. But Robyn, in terms of your question, shall we look at that
Yes,
slide?
let me bring that slide up. I'll just share the screen again. Okay.
Yeah, it's that last one.
This one here?
Yeah, yeah.
Yeah. Let me just make that bigger so everyone can see it. Here we go.
All right. So this is in response to the question of, you know, what might one of the skills be when we have reached an impasse in the haggle. And here what we're trying to do is to create other issues which are supplementary to the dominant issue of money. So this could be any conceivable situation where A is asking for 64,000, B is offering 48,000, and we're stuck. And you know, we might continue with the haggle or we might adjourn and so on. But what we want to do is try and create sub-issues on the table which will allow some flexibility in the negotiations and get us off, at least for a while, the dominant issue of the overall what we call in law the quantum. So the way this is to be done is to do either in screen share or face-to-face. And I used to do a lot of this face-to-face, but in fact, I do a lot of leasing agreements. They almost all end up like this in some or other form. So let's break down what was a single issue negotiation into a multiple issue one. And this is, of course, a payment plan. Many of you are very familiar with this, and you know, it may be appropriate or it may not be, but often it's the key to breaking the logjam on the haggle. So we reflect what each person wants. A wants 64,000, B only wants to give 48. A wants a down payment of 24,000, eight installments, 5K per installment, and to be paid monthly. And you can see what the other side wants. Now, why do we do this? We do this to try and ensure some trade-offs between people's priorities. So it may be in a cash flow situation, parties A's down payment is particularly important, the 24K payable within 48 hours by electronic funds transfer, where, you know, to satisfy the auditor, whereas the timing is not that important. For party B, it may be that the timing, they can only pay every 2 months for their own particular reasons or for tax reasons or whatever the case may be. So what we're trying to do then is get some trade-offs going between these different issues, ostensibly in the light of each side's priorities. Now that sounds complicated, but once you start on this, you find the question, what if, is quite helpful. So to party A, we can say, well, you're not being offered this, but what if you were to receive 24,000 down payment, you know, within the next 24 hours? What could you then do on the installments and the amount of the installments? And so we're trying to loosen up in a safe environment, because what the what if does is it guarantees that the concession party A or B makes is always conditional on receiving what they want. So it's a kind of a safe environment. And I've had up to, I think the record was about 10 different elements, which becomes complicated, but it gets us out of the crude haggle into multiple issues. So in fact, on money, there's always going to be at least one other issue, and that is when is it going to be paid? At least one other issue. And we factor that in so that the person may say, well, you know, I only received $50,000, but they're paying it. In fact, they paid it instantly. It's already in the bank account.
Okay, I'm just going to stop that sharing there, Laurence. So I mean, I found this really helpful in a whole range of types of mediations that I have done, from family property through to even, you know, time spent with children, because then you can factor in a whole range of things around who will do drop-offs and pickups, you know. Is there going to be any midweek? Are they all going to be weekend? What's happening with school holidays? You know, you can actually do it with whatever it is that is important to people. So again, it goes back to interests in some respect, that it's meeting people's underlying concerns and interests and some of their goals to be able to get things addressed. But we're doing it kind of on a monetary level and on a substantive level.
Yeah, definitely. And this goes back to the very first or very second question you asked. I mean, this is about interest-based mutual gains, because there should be something for each side in this proliferation of issues.
Yes.
And something, and this is a really important issue, we you know, to say the left hemisphere of the brain needs to be able to justify an outcome. Otherwise, they'll try to upset it, you know, or wake up at 4 o'clock in the morning and say, I conceded too much. And this at least gives you something to say to your partner, to your colleague, to down at the RSL club, you know, I didn't get what I want, but at least the bastards are paying me, you know, in 24 hours. So it's an important part of how we rationalize outcomes, or justify how we justify it.
And it goes back to that whole loss gain that you were talking about a few minutes ago. And I think that that's really important when we're kind of wrapping up a session, when an agreement has been made, is to remind people about what they have gained. Because you just mentioned there that, you know, post-settlement blues, where people can wake up in the middle of the night and think, oh, I've given away too much, I should have asked for more. You know, they have, you know, real post-settlement blues. But if you can, I guess, prime it positively before they leave around gains. And I find this kind of chart, particularly if you can flash it up again, either on the screen or, you know, on a flip chart or a whiteboard, and they can see the gains. Because you can kind of tick them on sides and show them in their separate rooms where they have made those gains. It just reminds them that, you know, they haven't made the wrong decision at the end of the day, and that they can commit to it. Yeah.
And I think one of the lessons, Robyn, which is implicit in what you're saying, is that the haggle isn't over even when you've got a settlement. So going back to where I do a lot of work these days, which is the common law work injury claims, and a lot of that is done by shuttle, and unfortunately mediators have a very limited role within that, as some of the viewers will know. But what I always do, I'll talk to the representative and say, I'm just going to phone your client up, who's often at a separate locality, or they may be with the representative, and say, look, you know, there has been a settlement, and then give some justifications as to you know, people need this. They need to be, in a sense, validated for a decision, which was hard to make. And that will be things like certainty, at least you know where you stand, you didn't get what you wanted. Finality, this means this part is over. Kind of renewal, at least you can start afresh, not having to go through all those undignified consultations and medical reports and so on. And I often end up with a little joke when the representative's there, and I say, and it means you won't have to see Bob or Susie on Monday morning. Again, you've kind of, you're out of the system, so to speak. So the left hemisphere really needs those justifications, which can be repeated to loved ones and others.
Yes. Yeah. So that's really good. And I'm just wondering, are there any other specific interventions that you use, kind of, that you think are really helpful, Laurence? I know we've talked about goals and addressing interests and needs. What about the other side, the risks? Is there a place for reminding risks and alternatives and the downsides of, I guess, of those?
I mean, Robert Angel from Sydney, the senior counsel. He's terrific in all this area, and he writes a lot. And I've had him in mediations, and he says it's all about cost and risk. That's what dispute resolution is about. And a slight exaggeration, because I think it's a bit more than that, as we know.
I think so.
but there's the element of that in all contexts, not only in commercial contexts. And I think it's easy to get away with the words. You appreciate the risk out there, but I think we have to make that a little bit concrete. So that's where I bring in appropriate cases, not all that often, but I will bring in, this is what a judge says about where you think you will go next, and I say that's the Supreme Court. The tribunal is even more hard pressed, so don't have an idealized version. So that's on the risk side. On the cost side, I mean, we know that it's in theory an important issue, but I think we have to again concretize it by talking specifically about, with the help of the representative, if they're there, what will have to go into the trust account next week, what's the cost of briefing counsel, et cetera, to make it much more specific.
Yeah.
And that's in terms of financial outlays. But what we all know is what the economists have told us, and that is it's the opportunity costs, which are really critical. And trying, in a sense, to quantify that, how much time and nervous energy and absence from work and et cetera, is it going to take to get all the documents that are required. So I think we have to move away from a rather vacuous notion of cost and risk to be as concrete as we can. That would be my view.
Okay, so in terms of being concrete, another, I guess, question, and I guess we're looking to wrap up fairly soon, is what is an executive summary on haggling for practitioners?
I see we have had one chat question, and you've answered.
And I've just answered that. So that was about recording. So yes, we are recording for those who are present, and it will be available.
So we've skirted over some key issues here, and it would have been great if we had the time available to dig into them a bit more. But in terms of the executive summary, I'd say that those of us who are the so-called adults in the room as the dispute resolvers or as the representatives, solicitors, barristers, FDRPs, and all the others, need the awareness and the kind of the knowledge base, not as a kind of prescriptive method of understanding, but as a provisional way of understanding the predictable things that can occur and how we might respond to them. So, for example, to warn the client that this is the way insurers play the game. They may get stuck 3 times on the same number, and this is the kind of tactics or tricks that may be used. I always laugh at the language of bottom line. What does bottom line mean? It's kind of lost all its. There's a bottom line at 11, and there's another one at 4 in the afternoon. So I think being able to have the knowledge awareness of ourselves as the professionals and to be able to educate our clients goes some way towards managing the haggle.
Yeah, so I think you're really right there, Laurence, and it goes back to what you were saying before around, education, that we have a role as educators and to manage expectations around parties and coming into our mediations, negotiations, and just helping them be prepared with some of that information that will cut through some of the haggle if we can manage that appropriately for them. So, executive summaries, I find, are quite routine internationally. I don't see a lot of them happening in Australia. And I think there's such a positive role that they can play for parties and representatives. So, so I'm glad you raised it, and I'm glad you endorse it. So that's good to hear. So
can I just end on one redemptive note, if I may, but you may have a final wrap up, and that is to appreciate if the haggle is what's happening before your eyes as a representative or an FDRP or whatever, they don't always settle. So I had, after doing many of these over a lot of years, I had one for good reason. I think it was only last week, where it almost began and ended where it started, 850,000 against 100,000 being offered. And that's kind of life. It's not necessarily our fault, however knowledgeable we might be. It happens.
And I think that's a really positive thing to end on, Laurence, that, you know, although we've been in the game for 30 plus years, not all our mediations, negotiations settle. And that even with the best knowledge and the best skills and interventions and understandings around all of this, sometimes, you know, parties shouldn't settle. Or they just need to, as John Wade used to say, they need to just suffer a little bit more out there in the real world. And then they may be more negotiable and willing to come back and maybe give it another try. Or maybe they do need to start that whole court legal process and feel how that feels. And then they may be more negotiable and willing to come back and try it again in mediation. So that door is never closed.
Absolutely. Yeah.
Okay, so that kind of brings us to the end of our Lunch and Learn session today, everyone. Laurence, one of the questions we had in chat was, can people have a copy of your slides? So are you okay with that?
Yeah, that's fine.
Okay.
Yeah.
All right. So we will include those on our website, the Global Training and Professional Development website, as well as the recording for this session. Okay, lovely. All right. So can I just say a huge thank you, Laurence? I know how busy you are, and I really appreciate that you've been willing to come today and to talk to all our participants and to future people who are going to listen to this recording, and just understand more about the Haggle and the fact that it does have a place in mediations and negotiations and conciliations. And when is the right place, and what are some of the skills and interventions that we can use to manage that haggle and manage ourselves as the dispute resolvers. So really appreciate your time and being with us and your knowledge. Thank you.
Haggle well, everyone. Bye.
So thank you, everyone. Bye. All right.